Police
Assembly's
Academy and by a group known as Ogara Group, which he says that Ogara Group is a security firm with presence in Dubai, United Kingdom, and several European countries. And eventually, after that training, he was licensed to offer private security. The report indicates that at the time he was arrested, he was providing security in Kenya mostly to persons in political sector, and he was at an advanced stage of registering his own security firm. Outside his training and daily work, the report indicates that he's a staunch Christian. He has sung, produced several music videos, and he was actively involved in church activities. It is further indicated that when this offense was committed, he was in a relationship with one Jacqueline Maribe, who was his co-accused, and they were planning to formalize their relationship. At the time of the offense, they were both residing at Royal Park Estate in Langata, and they had resided together for over 1 year. Medical condition, the report indicates that he suffers from asthma since childhood, and that is usually triggered by colds and dust, but is on medication. It is indicated that he has developed nerve problems, and that arose out of a gun incident which we spoke to in the judgment and in this matter. But it's said that the same is treated by painkillers, which gives him relief. On the offense, the report says that the accused person maintains his innocence and that he was shocked and depressed to be linked with the murder of the deceased. That he denies knowing the deceased, but acknowledges that he knows his brother. And it says that he grieves for the family of the deceased for losing her in a gruesome manner. The report indicates that he has good relationship with his family. The sister stood by him throughout the trial. They describe him, that is his family, and again this is important, as a social, overly generous, respectful to authority, committed Christian, and he believes in innocence, although he believes in his innocence, although he has painfully accepted the conviction. The family of the accused says that they have been stigmatized, faced a lot of stigmatization and financial drain in form of legal costs. That they are expressing empathy for the family of the deceased and pray that the perpetrators will be found. And finally, they pray for leniency in sentence. From the community point of view, the probation officer interviewed a senior chief of free area location, Dr. Samuel Macharia, who described the accused person as being well-mannered, respectful, and was not a threat to the community. That the community is shocked by the charge that was preferred against him and subsequent conviction. That they vote for his good character, social standing, as they have known him to be a respectable youth committed to church activities. Bishop Shadrach Olo of Agape Sanctuary Church says that the accused person is a member of his church. He is steadfast in faith, relates well with fellow Christians, And at the time of his arrest, he was a choir master in the church. He pleaded for leniency. The investigating officer, Mr. Maxwell Otieno, is indicated in the report as having described the accused person as an extremely dangerous person, violent in nature, as demonstrated by the fact that he was involved in an assault case with one Rogers at Club 1824 when he was out on bond in this matter. And that the reason why the case did not go forward is because the complainant withdrew the complaint. And the investigating officer called for the maximum sentence provided for under the law. The community from where the victim hails from in Thika described the victim as a person who had a promising future. They were shocked at her death, and they called for a stringent sentence. The family of the victim. The family of the victim are reported in the pre-sentence report to have stated that following the demise of the victim, the death occasioned them monumental psychological impact, and they are still to cope with the said offense and death. And other than the father of the deceased who has received psychological counseling, none of the other family members have had the benefit of the same. It is indicated that at the time the probation officer was interviewing the mother of the victim, she broke down severally and wailed, forcing him to stop the interview to allow her to calm down. She is said to have indicated that she does not understand what would cause anyone to brutally murder her only daughter, who was her confidant and a very close friend. It is reported that following the death of the victim and the deceased, she suffered prolonged depression and consequently suffered stroke. According to her, the only appropriate sentence is death. The father of the deceased is reported to have indicated that the extensive media coverage impeded their emotional healing. The younger brother of the victim is reported to have ceased watching news, stopped trusting people, limits his movement, avoids going to public places, and only does online jobs. It is reported following the death of the deceased, as already indicated in the submissions of the victim, having been the managing director of the family business in South Sudan, the business collapsed. The family became drained financially, and they were not able to meet their day-to-day needs, as that was the main source of their income. In a nutshell, the family of the deceased hold the view that the maximum sentence provided for under the law should be pronounced, and they acknowledge that whatever the case is, even that particular sentence will not console them or erase their pain. Finally, the probation officer And again, this is very important, and the court took note of the same. The probation officer, Mr. Andrew Kanyotu, in conclusion and his own observation, states as follows. He describes the accused criminogenic risk factors as follows. That he lacks stable partner relationships. He has antisocial personality patterns manifested by living on the edge. He is impulsive and a thrill seeker. He uses anger or aggression to control others. And finally, he says that the accused has a double personality trait. What is the recommendation in the pre-sentence report? He recommends that the court uses its own discretion in meting out the sentence, taking into account what is in the report and the sentiments of both the accused and the offender. So, that's a summary of the submissions by the prosecution, the victim's family, and the accused. So what sentence then would this court be looking at? First and foremost, let's acknowledge where our sentences are provided for. Section 24 of the Penal Code recognizes the following forms of sentences. 1, a death sentence. 2, life imprisonment. 'Or an imprisonment for a term of years. Detention under the Detention Camp Act, if that were the offense committed under that act. And it's important to interrogate these types of punishments, because then one needs to do an exercise of elimination inclusive and justify why this would not be applicable. And so I speak to them for our understanding. Fine, forfeiture, payment of compensation, finding security to keep peace and your good behavior, and any other punishment this court will find and deem appropriate. So this court cannot give a sentence outside those various recognized forms of punishment. When I considered these categories and types of punishments, I classify them into 2, custodial and non-custodial. So again, the question is, having taken into account the evidence as was adduced in this court, taking into account the submissions at this stage of trial, is this an appropriate case for a non-custodial sentence? I'll deal with that. We have already spoken to the fact that a sentence must serve a purpose. And so what purpose would a non-custodial sentence serve? One of the goals that a non-custodial sentence would serve is to give an accused person an opportunity for rehabilitation. And so, is this accused person eligible for rehabilitation? My answer was in the negative. For simple reason that a person who is given an opportunity for rehabilitation must first and foremost himself acknowledge, commission of the offense, and the need to reform. Without that attitude, there will be no need to consider rehabilitation. It will not work. He will not appreciate, and of course then it will be an order in vain. Alongside rehabilitation, we have the goal of reintegration. And when one is considering reintegration, then several questions must be answered. We are releasing this person to the society. Is that safe? Is the society safe? We'll answer that question. What about restitution, restoration? I've already spoken to this and said this is a situation where you are telling the accused person, make good the harm. Is this a case where an accused person can make good the harm in form of monetary compensation? As I was dealing with this particular goal, my mind took me to a case I deal with on a day-to-day basis when I'm dealing with appeals and more so in civil cases, and someone has come before the court because they were involved in an accident and they suffered bodily injuries. And in the case of Coastal Kenya Enterprise Limited versus Mushiri, is a civil appeal number 84/2016. This is what the court said, and which I fully associate with. Money cannot renew a physical frame that has been battered and shattered. And so in my considered opinion, this is not an appropriate case where the sentence that is being meted out is aimed at restitution, restoration, and or compensation in monetary terms. What about reconciliation? Should this court give a sentence that would aim at reconciling the two families? Having listened to me read out the pre-sentence report, it is very clear that these two families are incapable of sitting to negotiate, to reconcile. Where does that leave the court? The court was left with only two objectives to look at: retribution and deterrence. And I've already spoken to them at the beginning of this judgment. That is where the court punishes the offender, at the same time deters the offender from repeating the offense if given an opportunity, and the general public from committing a similar offense. The purpose of law and the aim of law, in my understanding, is to maintain law and order and protect the citizens of a particular state. That is why one of the objectives of sentencing is community protection. And therefore, the sentence any court pronounces must speak clearly to the community condemnation of criminal conduct. At this point, I was drawn, and I'm entitled as a court, to take judicial notice as I talk about and discuss general deterrence. To take judicial notice of the social justice concept. And that concept, in my understanding, speaks to the court being live to the happenings in the society at a given time. And my mind, as a court, my understanding, my reading, is that in recent past, there have been numerous reports of senseless murders targeting persons of female gender. let this not just be my words from where I sit. In an article dated the 26th January 2024, Amnesty International Kenya noted that a woman is killed in this country in every 2 days. And I will quote from the article so that I attribute it to where it belongs. Let me read the caption from that article. Amnesty International Kenya strongly condemns the profiling, torture, and killing of women and any other individual based on their identity. Over 10 cases of femicide have been reported across the country since 1st of January 2024. That is, every second day, a woman has been brutalized and killed because of her identity. According to statistics from Africa Data Hub, between 2016 and 2023, over 500 women have been killed. The majority of those murdered were below the age of 35 years and were killed by intimate partners or people known to them. According to the Africa Data Hub, a regional network of data organization that traces such killing based on newspaper reports, it states that about 500 women have been killed in Kenya from January 2016 to 2023. Now let me draw ourselves back home. In an article published by the Daily Nation on 27th of January 2024, it indicates that 16 women have been killed since January 2024. The most disturbing was a case of Rita Mweni, a 20-year-old student at Jomo Kenyatta University of Agriculture and Technology, who was lured to a short accommodation apartment at Roysambu, commonly known as Airbnb. She was murdered, her body was dismembered, her head was dumped at a different location, and one can only but consider the words said by Dr. Jansen Odwal, the pathologist. And these were his words. He said, "This is the first time I've come across such an incident in my forensic life. I have never come across such an incident." And so when we are considering the public's denunciation of a crime, one cannot live outside the prevailing circumstance in the society. It is the understanding of this court that these reports speak to a situation whereby the social fabric of the society has been torn into two, right at the middle. And the court must then live to its role to protect the society. And so, having ruled out a non-custodial sentence, and may I just say this, the accused person is also not even asking for a non-custodial sentence. I read the submissions on mitigation, and in their own writing, they tell this court, Muratetu did not declare a death sentence to be mandatory, but then the court can give a custodial sentence. They say a custodial. There is nowhere in that report where this court is being invited to consider a non-custodial sentence. So we are at a stage of a custodial sentence. And I've already made reference to the sentences that this court can pronounce under Section 24. Fast track the judgment. The following factors have been considered by this court as I come to the tail end of the judgment. And there are only 3 sentences that are open to the court. A sentence for a term of years, life imprisonment, or death. The question that we all must ask is this: how many years, and what would be the basis for those years? Secondly, and for the lawyers before me, and today I am well populated, thank you for coming. We are all aware of the jurisprudence on life imprisonment, where one of the courts has said it is unconstitutional. The latest decision which I've quoted in this matter says that life imprisonment is 30 years. So the question that one would then ask is, if life imprisonment, and of course is acceptable, it doesn't mean the life which that person will physically live or be alive. So if it's 30 years and with remission, then we'll be looking at where this court is sentencing the accused person to 30 years. With remission, he serves 20 years and his life moves on. These are issues the court had to think of. I have, of course, taken into account issues of human rights. I've taken into account Article 26, that says a person's life should not just be deprived without good reason. I have made reference, and maybe I should then let you know, to the international instruments that speak, and I need to do this because it's important, to the preservation and the right to enhance an individual's human rights. The International Convention on Civil and Political Rights, which has been ratified and which then of course becomes part of our law under Article 2, Sub-Article 5 and 6, says this, and it's important that I read it out because you need to know that. It starts by saying every human being has the right to life. And I stop there and I tell myself as a court, every human being has a right to life. That every human being includes the victim and the offender. It then says this: this right shall be protected by law. No one shall be arbitrarily deprived of his life. Most of the time when we read these provisions, we speak to them as they relate to the offender. My understanding is they relate to both the offender and the victim. That convention states as follows: that in countries that have not abolished the death penalty, a sentence of death may be imposed only for the most serious crimes in accordance with the law in force at the time of the commission of the crime. So these international instruments that speak to human rights do recognize that there are exceptional circumstances when the death sentence may be inevitable. Let's look at Article 4 of the Africa Charter on Human Rights, on Human and People's Rights, ratified on 23rd of January 1992. It provides that human beings are inviolable. Every human being shall be entitled to respect for his life. His, in my considered opinion, includes her life, and the integrity of his or her person. Again, it reiterates, no one may be arbitrarily deprived of this right. Muratetu reflected again the Supreme Court says that you can indeed impose a death sentence for most serious offenses. Extremely grave. So the question is this a case of serious crime? In answering that question, I considered the following. What the evidence said. And the first thing that was revealed by the evidence is the manner in which the offense was committed. I want to remind ourselves of the judgment I delivered on 9th of February, where I indicated clearly that the evidence of the doctor who conducted the post-mortem report indicated that the person who perpetrated this offense cut the throat of the deceased through and through. In that judgment, I spoke to an understanding that the person was not an amateur. The person must have had some training. And remember, the evidence even revealed that after the offense was committed, the deceased was put in the bathtub and the shower tap was put over to run the blood off. When I read the report presented by the probation department, where the accused person himself says, I have been trained by the Dubai Police Academy and an Ogara group, I thought that corroborates the finding of this court that there was full scale for commission of the offense. I do recall saying in that judgment that the manner in which the offense was committed did not at any time intend to give the deceased one more minute to live. I do recall throughout the trial, no any other than the counsel representing the accused person in this trial throughout kept on referring to the incident and the scene of crime as a slaughterhouse. Secondly, we have had the benefit of looking at the photographs showing the body of the deceased and the injuries. I would certainly not display them there, certainly not, at least for the benefit of the family. And I did indicate in my judgment, no one would like to look at them again, not once, not twice. Now let's look at, and this is very critical, because it is not the court just making an observation, it was a brutal murder. Let's look at how the defense, that is the submissions in mitigation by the accused person himself, describes the offense. I will now read to you how they describe the offense verbatimly. They say that it is a tragic, curious loss of life on extreme circumstances bordering on an act of absolute madness that is beyond understanding. So even the defense joins the victim's family and the prosecution and the court in arriving at the conclusion it was a gruesome murder. Horrific, frightening. Let's now look at another important aspect that the court has considered. The consequences of the offense. from where I sit as a court, each one of us is responsible for the natural and the probable consequences of our actions and or omission. So it's not just an issue of committing an offense, but the far-reaching consequences of that offense cannot be ignored. And so in this case, it is undisputed that the deceased was the managing director of the family's business in South Sudan. It is undisputed that the business collapsed after her demise. It is undisputed that that was the source of income for the family, and we can all appreciate the natural and probable consequences of that. I have already made reference to the fact that the other consequence of this offense is what has been described, and unless there is evidence to the contrary, I believed it because it's in the probation officer's report that the mother of the deceased suffered depression and stroke, and she has hardly healed. I've spoken to what the brother is said to be undergoing. This court, and I never lose out on anything, I try to get as much of in-depth of the material before me as I can, has been invited to take cognizance of the fact that the father of the deceased at one time said, I will let go. That did not form part of my record, because what formed part of the court's record is his sentiments as expressed in the Brigade report, and that is what I will safely go by. But I'll be concluding with one or two other findings that could probably remove us from that mind thought that the father said, do not, vengeance is not mine. I also want us to just, in concluding, other than looking at the manner in which the offense was committed and the consequence or the impact of the offense, I took a bit of time to look at the character of the accused person. I have already spoken to how the probation officer describes him: aggressive and social personality, and concludes he has double personality trained. But let's look at what else this court was able to gather while hearing this matter on the character of the accused person. It was the evidence of the guards at Royal Park Estate, where he was staying, that he would not allow himself to be searched. He would brandish a gun and say, I work at State House, and just drive off. It is the evidence of the brother of the deceased that even during the hearing of this case, at one time, he blocked his car when the case was going on. And of course, you have heard from the IO, even when he was out on board, he was still involved. I'm not condemning him because there's no child before me. But the court cannot avoid looking at this. Because at the end of the day, the question is this: is this a person you want to release back to the society? And these issues become extremely critical for consideration. Finally, this matter and the evidence adduced does not lead to a conclusion that this murder was accidental. That the perpetrator did not have an opportunity to think about the consequences of his action. It was intentional. It was not a defensive act. It was not out of provocation. It was planned, it was intended, and it was executed. And those who do not subscribe to Christian faith, bear with me. I do, and that's the only place I could make reference to. In the book of Job, chapter 1, verse 12 to 13, this is what is written. I think I looked at the, was it NIV? You can find out, speaks to the same thing. This is what the Lord said to Satan. Behold, all that he has is yours. Only do not lay a hand on his person. I'll repeat. Behold, all that he has is yours and is in your power. Only do not lay your hand on his person. The provision of life is the preserve of God. And I find no room anywhere for a person to take another person's life unlawfully. In my very final conclusion, join me in listening to these wise sayings on murder. 1. In the act of murder, one person's life ends, but countless number of lives are forever impacted. I will read again. In an act of murder, one person's life ends, but a countless number of lives are forever impacted. Secondly, murder leaves behind a trail of shattered dreams and broken hearts that can never be healed. Murder leaves behind a trail of shattered dreams and broken hearts that can never be healed. I have said the accused person before me is 33 years. The deceased was 28 years. Thirdly, the act of murder is a heinous crime that challenges the moral fabric of society and demands justice. And so it is not just a loss to the immediate family. Of course it is in the highest degree, but it's a loss to the society when one is killed unlawfully. And so, based on everything I have said, I have ordered that the first accused person before this court being Jowie Irungu alias Jowie. Shall suffer death as provided for the offense of murder under section 204 of the Penal Code of Kenya. And is that sentence is lawfully set aside by a court of competent jurisdiction. That is the order of the court. Thank you.
And sentencing decision and tax proceedings.
Any other counsel wish to address the court?
My lady, the shame for the state, apologies I was late. We just want to thank the court for bringing this matter to a close. You're in alignment with your sentence, and we still would like a copy of the sentence once it's available. But we are grateful for the court's indulgence and the way it has handled this matter. Thank you,
Any other?
Yes, my lady, on behalf of the victim's family, we would also wish to thank the court most sincerely in the manner in which the court has handled the proceedings. The family feel that justice has been done. We also would wish that the court supplies us with a copy of the sentence and judgment once the same is ready. Thank you.
Okay. A right of appeal is a constitutional right which the accused person should feel free to exercise. Is important. You are entitled to the proceedings, the judgment that the court will delivered on today's judgment. And when the file was brought to me, and I'm sure by now my judgment is available. It was actually available the same day I delivered, before 7. So just ask the Honorable DR to give you the proceedings and the judgment. I've always said that my judgment is never accessible until I've delivered. My judgment on sentence is here. As I was delivering, I could see quite a bit of typo. So it's just an issue of polishing it. You should have a copy. I'll sign a copy before end of day, and you should have a copy. Okay? So unless there is any other person who is addressing the court, may I have the last bite of the cherry? First and foremost, please allow me to sincerely thank all of you. And that means the parties in the matter, the members of the public, the press, for the support you have given this court. I took over this matter from my brother Justice Wakiaga, and as much as I know there has been a bit of complaint that he's taken long, we did the best we could. We lost a bit of time during COVID when activities of the court slowed down, but take it from me, when you look at the way this matter, and I'm not blowing my own trumpet, I have no reason to, but one thing we must appreciate, that this matter was being had alongside other matters. And let me say something that probably you wouldn't know. When I was presiding in the criminal division of the High Court here in Nairobi before I was transferred, I did a prison visit at the Nairobi remand, and those inmates took me on this matter. And their question was, kwa nini unakimbiza kesi ya Jowie na Maribe na walituacha hapa na uendeshi kesi yetu haraka? I didn't realize that we were moving fast with this matter. So for the members of the public who have felt that when we talk about only 6 years, it's also important to consider that there are other matters. And so please, we are not making an excuse for anything, but it's good to just make an understanding and of course apologize for any inconvenience that may have been caused by any delay in the hearing of this matter, but set the record clear, we did the best we could. And so I thank you for your support, because other than the time we had a bit of challenge when I think Professor Nandwa had a personal issue, all the time the lawyers were in court and we were able to move on. I have not had a disruption in this matter. The press, I must really congratulate you. I have not had to summon you here to say, what did you report? Except recently, which I will not talk to, but maybe I should. When I was reported to have said something which was said when I was still driving to this place, and I was still on my way here. And I'm reported to have said that the accused person, Jacqueline Maribe, must come to court even when she's sick. I don't know where, was it KTN or what other media house reported. Sikujua hiyo wametoa wapi, lakini msijali, hiyo imeisha. Iliisha hivyo tu. You know, you must also choose the battles to fight. But what I'm saying is that generally speaking, I really want to thank you. I know you are quite a number of you, and you are understanding, but I've not had any reason to complain that you have not reported these matters factually correct. So thank you very much. Please keep up the good job you're doing. For the rest of us, thank you for coming, supporting the judiciary as it were. Your patience with us is highly appreciated. And with that, I wish you a good day for the rest of the day. For our staff, the court assistant, and of course, my other good friends, I can even see one whom I've worked with for a long time, a gentleman there. Umefanya kazi miaka ngapi? Over 10, eh? Please don't say anything more, they'll start guessing my age. So thank you very much, court assistant. Unless we have any other matters that are before the court, I would request then we officially adjourn the court.
The court is adjourned.